We're live.
Good afternoon. This is the 25th of March, 2021, and it's the hearing of the House Judiciary Committee. We have a number of bills today relating to policing that are the Senate bills that they passed out the last several weeks. Some of the senators are going to join us and give brief testimony regarding the legislation. Some are not. The speaker, as we set out rules regarding bills that were crossing over, set a relatively straightforward but set of rules that strongly limited the number of people who were going to testify. We are expanding that a little bit because of the importance of this issue, and so we've tried to ensure that there are people on every side of the issue. Having said that, we're going beyond the speaker's recommendation. On the 9th of February, this committee heard 237 different pieces of testimony on these broader issues. We had a work group that met from about the middle of June all the way through to the start of session with regard to this issue and took public input the entire time. And the Public Safety Subcommittee heard from all parties regarding these issues and heard in great detail from the parties regarding these issues. So at this point, we have the cross-filed bills, and we are going to hear from the witnesses for 3 minutes each. Everybody will get 3 minutes, and then we'll take questions from the committee on each individual bill. With that, we're going to begin with Senate Bill 599. Senate Bill 599 was introduced by Senators Smith and West. I don't believe that either one of them are here today. I don't know that there's anyone else here to testify on behalf of the Senate Bill 599. It has to do with the procurement of surplus military equipment. The senator indicated to my office that he is basically just submitting on the bill, and so we will allow him to do that. He is running JPR right now on the other side of the street. So out of deference to the chairman, we will consider that the hearing for Senate Bill 599 has been held, and that bill has been heard by the House Judiciary Committee. Now we're going to go to Senate Bill. I have to get used to this now because now it's different. Senate Bill 600. Senator Smith, again, the chairman, is running the committee on the other side. We're going to hear from a total of 5 people testifying, one person testifying in favor, one testifying favorable with amendments, and 2 people testifying opposed to the legislation. And so with that, Dylan, if we could please see Lawrence Greenberg. And we'll also hear from Sheriff Gaylor from Harford County. I see Mr. Greenberg. Why don't we'll take Mr. Greenberg first, and then we'll go to the sheriff, and then we'll go to Joe Riley and Steve Kroll. Mr. Greenberg is in the car. Mr. Greenberg, if you would please.
I just pulled over.
Yes.
I did.
Great. For 2 minutes, I'm sorry, we'll go for 3 minutes, please.
And I believe this is on the body cam bill.
This is on Senate Bill 600, which has to do with the Office of the State Prosecutor.
Okay, I had withdrawn my testimony on this. I'm supposed to testify against 70 today, or I'm sorry, in favor of.
Okay, well, we'll see you later then. So we'll go now to.
Thank you.
And I see the sheriff there. He's signed up favorable with amendments. We'll hear from the sheriff. And if you'd like, please go ahead. We'll hear from you for 3 minutes, and then there will be questions, I'm sure.
Yes, sir. Good afternoon, Mr. Chairman, members of the committee. I'm Harford County Sheriff Jeff Gaylor, and I'm appearing before you today to offer my support for Senate Bill 600. However, there are a couple of amendments that I would like to suggest that I feel would improve the goal of this bill, which is thorough and transparent investigations and, when appropriate, prosecutions related to police encounters that result in the death of an individual. Sorry, my radio was talking there in the background. I've been before this committee several times over the past few years on similar bills, and my perspective pretty much remains the same. As the elected sheriff of our county, the citizens of Harford County have entrusted me with the duties of my office, which include these types of investigations when they sadly do occur. It is me, like each of you and our state's attorneys, that the residents of our counties can hold accountable through the power of their vote. They have no ability to hold a chief or a sheriff from an outside jurisdiction accountable, and have no way to hold an appointed state agency head accountable. As an elected official, I understand the power of the vote, and I do not feel this should be stripped from our citizens. That said, I also recognize the need to be transparent in these types of cases, and that is why I've offered in the past my support in the past and today for parallel and collaborative investigations. Having one or two investigators from an outside agency or a yet to be formed state agency assigned to the case from the outset maintains the investigation with the agency of jurisdiction while also accomplishing the goals of ensuring thoroughness and transparency, and is much less fiscally impactful for taxpayers or manpower intensive for the outside agency. My second suggestion for an amendment concerns the members of the task force that is proposed in this bill. 4 of the 6 members are elected representatives. However, the constitutionally elected office of sheriff is not included. I would propose an amendment that adds a representative from the Maryland Sheriff's Association, and although not an elected office, I also feel it would be wise to have a member from the Maryland Chiefs of Police Association as a part of the task force. Thank you for your time this afternoon, and I'm of course happy to answer any questions you might have.
Other questions for the sheriff? We'll start here. Seeing none, we thank you. I'm sorry, Delegate McComas.
Sheriff Gaylor, going to the folks that you want to investigate, if the incident occurs in Baltimore City, you would want the Baltimore City Police Department to be part of the investigation of the incident, correct?
Absolutely. I think the Baltimore City Police Department has the manpower. They have the staffing, they have the manpower, they have the intimate knowledge of those individuals that may be witnesses or involved in the case. They have that firsthand experience that comes with policing your community. It just comes with it. But to assign members, either Bill a couple of years ago was from the Attorney General's office, state prosecutor's office has been discussed, or yet to be state created agency, to have those investigators have full access and be assigned to the investigation, I think accomplishes everybody's goal of making sure that, the reason for transparency is to make sure nothing goes on behind the scenes, no kind of cover up. And I think that offers that ability by giving them access. And again, the investigation, I've said this before, the investigation starts the minute the crime scene tape starts to go up. So, this task force is going to look at it that's proposed in Senate Bill 600. But at what point does the local agency become part of the investigation? I mean, when you're putting the crime scene tape up and determining what is the crime scene, that's technically part of the investigation. So I know the task force has its work cut out for them, but I think that this is a proposal that no matter who that outside entity is, gives them full access to everything to make sure that it is completely transparent.
So Sheriff Gaylor, at this point, we don't know who the outside agency is or the qualifications of who their detectives will be to investigate a fatal incident or a very serious incident involving the police department.
Well, right. But under what I would propose as an amendment to the legislation, you would have those experienced investigators that are still here with my agency or police departments or sheriff's offices from across the state working the investigation. And I'm sure whether it's a future state agency or the state prosecutor's office, they're going to go out and look for, homicide detectives retiring from different police departments or people with, that sort of qualifications to be those investigators. So again, it has to be a person who understands what they're looking at. I thought the proposition a couple of years ago, again, for the Attorney General's office was a good suggestion. But I do believe, and especially as an elected sheriff, that this is what the citizens elected me to do. Sadly, again, when these things do occur.
Just a quick follow-up, Sheriff Gaylor. I guess maybe I watch too much TV, but you always hear the tension between the feds and the local police departments. When the feds come in, they sort of like want to take over, and they might not even know where the police department is in the jurisdiction they're investigating. Do you feel there would be a problem between the state agency and the locals, whichever one they would be, that had the incident occur, so that we wouldn't get into that, who's in charge and kind of a turf battle?
No, I think the legislation would ultimately passes, and whatever becomes law is going to define whether there'll be no need for a turf battle. It's going to show who has the authority to conduct the investigations. And when the feds come in to conduct their own investigation, civil rights investigation, that's certainly something that is their complete purview. So I don't know of any cases anywhere across the country where a chief or a sheriff has standed up, attempted to say, no, you're not coming in to investigate this. They have full authority to do so. And again, I think it's more palatable that I want to ensure a complete and thorough and transparent investigation is conducted. If there are members of this community who don't feel, because of political affiliation, because of distrust of police, that that's not the case, I don't believe that's the majority of our county, but if that's out there, then we should address that concern. And again, I think by having outside experienced people come in and work the cases concurrently, parallel with us, with full access, is a way to address that.
So are you telling me that Hollywood doesn't properly present how law enforcement works? No, I'm just kidding.
It doesn't represent how any profession works, but policing in particular.
Okay, thank you, Sheriff.
Yes, ma'am.
All right, we'll go now to Delegate Cardin.
Thank you, Mr. Chair. Just quickly, Sheriff Gaylor, do you represent the association? Or are you doing this on your own from your own office?
No, this is my own. I do believe the association has put in the letter of support as far as the adding a member from the Sheriff's Association and the chiefs to the task force. As far as the proposal for the somewhat a parallel investigation running concurrent, that is just for me.
Okay. So, and my understanding is what you're just suggesting is that the folks that are that are possibly that there could be a possible wrongdoing by somebody inside your office because of this investigation is gonna determine whether there was wrongdoing or not. And you think that that your internal folks should be able to do their own parallel investigation, or should be part of the investigation by the prosecutor's office or the state attorney's office?
No, I believe Senate Bill 600 leaves the investigation with the police department of jurisdiction, be it a sheriff's office or Baltimore City, Baltimore County, and it's the prosecution and that Senate Bill 600 addresses. I believe it should stay with that police department. The men and women of this office are entrusted, as I am as the elected sheriff, to conduct all sorts of serious investigations into serious crimes, be they rapes, robberies, sexual assaults, or unfortunately use of deadly force when they occur. So I am supportive of is that the primary law enforcement agency, and particularly as an elected sheriff, that we maintain the ability to fulfill that need in our community and that service to our citizens. However, opening up to having independent agency members, again, maybe from the AG, maybe from the state prosecutor's office, or I know the House bill proposes a yet to be named state agency that instead of staffing up, I don't know, another police department for all intents and purposes with Lord only knows how many investigators, you could do it on a smaller scale, and those investigators have complete jurisdiction, authority of law, and access to be a part of that investigation by the local police department.
Thank you.
Yes, sir.
Thank you very much. We appreciate it, Sheriff. And that completes the favorable with amendments
Thank
testimony.
you.
We're going to hear now from the next two people, Joe Riley and Steve Kroll, who are in opposition to the bill. They're going to be let into the room, and then we will give them 3 minutes each. See both of them. We just need to see one of their faces. All right, Mr. Kroll, if you want to start for 3 minutes, that would be great.
Thank you, Mr. Chairman. Thank you, ladies and gentlemen of the committee. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association, and I'm here against and ask for unfavorable report as to Senate Bill 600. During the summer, we held a work group, you all held a work group about police reform, and in that work group, you did not recommend anything in this bill when it comes to somebody else other than state's attorneys handling their own investigations. So agreeing to this bill would be contrary to all the hard work that went in over the summer. And that hard work said there are no recommendations for an independent investigation on behalf of state's attorneys. And on behalf of Rich Gibson, the president of the Maryland State's Attorneys Association, we are against anybody but ourselves. Officials, and we should have those particular investigations done by us. Second, I want to recall something. I went back to 2015 and I saw the video in 2015. It was House Bill 112, sponsored by Delegate Conaway. And it was also another bill co-heard at the same time. It was House Bill 813. And I sat right next to Emmett Davitt, who was the state's attorney, the Maryland State's Attorney, state prosecutor. And he said, sitting right next to me, that state prosecutors were not competent to handle police investigative shootings. They did not have the resources and they couldn't do those investigations. He sat right next to me. He told this hearing that, and those bills then failed. This bill should fail also. Not the state prosecutor, not any other independent investigation, but the state's attorneys, the elected state's attorneys, should be the ones who investigate these cases. And for that reason and that reason alone, we'd ask for unfavorable and voting against Senate Bill 600. And I'm happy to answer any questions.
Mr. Riley.
Thank you, Chair Clippinger, Madam Vice Chair, members of Judiciary. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland State's Attorneys Association. We are seeking an unfavorable report on Senate Bill 600. My understanding of the intention of the bill is that the JPR was concerned that smaller jurisdictions lack the manpower to handle the investigations that a shooting or a death in police custody would maintain. But I think it's clear that we need to separate an investigation from a prosecution. The investigation is done by law enforcement, done by some entity, Maryland State Police, the sheriff's office of that particular county, a large jurisdiction who has a homicide division would do that investigation. The Board of Medical Examiners would do the findings as far as the cause of death. What comes to the state's attorney's office is the investigation when it's complete, and then the prosecution proceeds from there. The size of the shop isn't really relevant, depending on what county you're talking about. And if you're assigning it to the state prosecutor's office, you have to remember the state prosecutor's office has a little over $1 million budget for the entire state and has a prosecutor's office that is not larger than this office. As far as we have 5 prosecutors here. I don't think they have many more in Towson. And also asking an office in Towson to handle the prosecution in various jurisdictions, yes, I understand it would be after the state's attorney in that office makes the determination, is not really an ideal function. And this is also already covered in the Maryland Constitution by the powers of the Attorney General. If a local state's attorney makes a decision that the Attorney General thinks is erroneous, or there is some outcry that it is erroneous, the Attorney General has the authority to request from the governor authority to impanel a grand jury in that county and can do so. So the solution to this problem, if it exists, is already in the Maryland Constitution. And I think we need to be very clear as far as investigations done by very powerful police agencies versus prosecutions, which can be done by any law office. And I'm sure the members of you who have prosecuted can distinguish the difference between that. Thank you.
Thank you very much. Are there questions for this panel? Seeing none, we thank you very much. That concludes the testimony on Senate Bill 600. We're now going to go to a string of bills. If we could have Senator Carter please brought in, a string of bills from Senator Carter. Senator Carter is going to talk broadly about all four of the bills, and then she is going to go back. I'll repeat this when Senator Carter's on, so she knows the rules of the road. Hello, Senator Carter. Here's what we're going to do. Senator Carter is going to talk broadly about the four pieces of legislation that she has before us. And then she's got to head back to JPR. So we'll do that. So we'll treat that as her testimony on each one of those, but I will then take each bill individually. So we're now on Senate Bills 178, 419, 626, and 627. Senator Carter, if you'd like to talk about all of them generally, that would be great. Go right ahead.
Thank you so much, Chairman Clippinger and members of the committee. I really wanted to come to introduce myself to some of the new members that I haven't met yet, and say hello to some of my old friends on the committee. I served on the House Judiciary Committee from 2003 to 2016, and some of you may be shocked to know that during that time, I was one of only two women attorneys, myself and Delegate Kathleen Dumais. So this committee has changed quite a bit since then, and I want to say a special hi to Delegate Rachel Jones and Delegate Cham, who I have not yet personally met, even though Delegate Cham and I were on a committee together. I promised the chairman I'd be quick, so I promise I will. We've all had a lot of our fill of talking about police reform, you all with the work group that you did over the fall and JPR as well. And so you already know to a large extent what these bills do. I would just stress that it's important that we pass the strongest bills possible. In each of these bills, there are aspects that I think the Senate got it right, got better, and some that I think the House did better. Specifically on Anton's law, I would encourage us to stick with the Senate version, which I think is a better bill. I think the House bill that adds the language related to the compliance board and gives them greater authority than what they would normally have, I think goes too far and is unnecessary on Anton's law, the Senate Bill 178. I believe there's already adequate checks and balances in Anton's law as passed by the Senate, but I'm happy to discuss that in conference. Senate Bill 419, which is no-knock warrants. Well, if I had my druthers, we wouldn't have no-knock warrants, but both houses decided to keep a version of no-knock warrants and put great restrictions on them. I love what the Senate did, but I think that the House adding in other requirements for regular warrants that are not no-knock is even greater. And so I applaud the House on that, and especially all the members of this committee that worked so diligently on that, as well as on the work group. Use of force. There are aspects of use of force that I think the Senate did very well in terms of giving specificity to terms and in terms of criminalizing duty to intervene and duty to report. I want to say that, some of these bills for me personally go back all the way to 2009, where I've been sponsoring various versions of LEOBR repeal, use of force, some of the things in use of force and other stuff. And so they're very, very important. And I'm glad that we put all of this work in. On use of force, I want to give a special shout out to my Legislative Black Caucus committee members, Chairman Delegate Deborah Davis and Delegate Bartlett and Delegate Crutchfield, who worked so hard just with Black Caucus on these priority items and did a great job on use of force. So I look forward to working with you all in conference committee. LEOBR repeal, that is probably the bill that I've said that if we ever pass that bill, some of you might be happy to know, I said I'd retire on that because I think it's so critically important for the state of Maryland and for the people of Maryland to know that we do not put law enforcement's due process on a hierarchy way above the people, but we see them as equal, entitled to due process rights, but not greater. And so for that, I do think that the House version is a little bit more complicated, makes it more complex maybe than I would choose, but I think it's better for me to reserve my comments and my work for the conference committee. I know that the House believes, because I've talked to many people and I've read the media, believes very strongly that we've gone far enough on civilian oversight. I would just argue that the Senate didn't, and the House does a better job in terms of the accountability boards. But at the end of the day, there are some areas of the country that have created civilian oversight entities that actually have the full responsibility for investigation and discipline. And that's something that we should be willing to entertain that in Maryland as well. And with that, I have concluded my testimony. I thank you for your time. I promised Chairman Clippinger I'd be faster than light. I'm trying. I am done, but I do see a question, I think, from Delegate Moon.
I have to be unmuted. Delegate Moon?
Sorry, I was waiting to be recognized. Thank you, Mr. Chair. Good afternoon, Senator. It's been a long time. Even on Zoom, I feel like I haven't seen you in ages. I have to just ask a couple follow-ups about your comment about preferring the Senate version of Anton's Law. And I have to admit, I've not I didn't listen to the Senate floor debate, but I caught a little bit on the news and on Twitter about some of the things that were being discussed. And I guess I wanted to catch your understanding of what was done across the street. I heard there is a expungement provision that got added somewhere in committee. And then I heard there was a separate expungement type of discussion that happened on the floor and that did not get adopted. And so I guess, could you just explain what those two would have done and which one, what the provision that did get adopted does?
So I think, to my recollection, there was no expungement provision adopted in the Senate version of Anton's Law, but what was discussed is the fact that in our version of Leobor repeal, I use lightly, in our version of Leobor repeal, we, the Senate chose to keep the expungement provision, which my understanding the House bill does not. So I actually applaud the House in not doing that. So the discussion was whether or not some of these records, how long they'd be available. And the discussion was that under current law and the version of Leobor repeal that the Senate passed, there would still be a 3-year period of time that these records could be available. But frankly, under the House version of the Leobor repeal, it would not. And so I prefer the House version of Leobor repeal to that extent, but still the Senate version of Anton's Law, simply because it gives the power to the custodian of records within the police agency, or that's overseeing it for the police agency. And I think that with the House version, my understanding of the House version is that it gives a second layer of discretion to the compliance board and actually uses a very subjective standard, possibly of vexatious or frivolous denials. So if that's in fact correct, that's the part I don't like about the changes in Anton's Law in the House bill. But I do like the expungement provision that you kept in Leobor repeal.
And sorry, Mr. Chair, if I could just to clarify, the specific expungement in the Senate version allows all records to be deleted after 3 years, or is it, you chose some category like unsustained or something like this?
Yeah, unsustained.
Okay, so after 3 years, unsustained records come out of the database unless we don't take that. Got it. All right, thank you.
All right, thank you so much. Great to see you.
Thank you, Senator Carter. We'll go now to people who are going to testify on each of the bills, starting on Senate Bill 178. We're going to go to those in favor first, and that'll be Yannette Emanuel and Davon Love. Then we will be hearing from Jerry Eaton, Clyde Boatwright, and Michael Davey. So we'll hear from Ms. Emanuel and Mr. Love. As soon as one of them appears, give them 3 minutes.
Good afternoon. Thank you for having me. My name is Yannette Emanuel. I'm the public policy advocate with ACLU of Maryland, and I'm here today on behalf of the Maryland Coalition for Justice and Police Accountability. We're here in support of SB 178. This bill is very modest. It does not mandate disclosure of any record. It simply moves records of investigations into police misconduct from the category of personal records, which can't be disclosed at all, even if the department wants to a category of investigative records, which are discretionary denials. That means that they are not categorically shielded from disclosure, but departments retain broad discretion if discretion is contrary to public interest to withhold or redact to protect other important interests like privacy, the integrity of investigations, confidential sources, etc. But if the record or part of it will of it will be withheld or redacted, the department has to have a good reason, and that reason can be challenged in court if the requester thinks that it's in bad faith. It is critical that the public has access to records of all administrative investigations of police misconduct, excluding technical infractions. A small category of possible offenses leaves out huge swaths of significant misconduct like illegal searches, including strip searches, illegal stop and frisks, illegal arrests without probable cause, making racist or other discriminatory comments online, etc. And trying to define only a limited category of disclosure, limited category of disclosure also ignores the fact that categories are not how these categories are not how police categorize their investigations. For example, Officer Pinheiro, who was convicted more than 2 years ago for staging the discovery of drugs on his body cam during a search, was convicted of official misconduct. He remained on the force for more than 2 years following the conviction, getting paid until he finally resigned this past December, which is why we need disclosure of all alleged police misconduct, not some limited class of cases. And finally, I'll just close by saying, just to remind the committee, the underlying principle behind the Public Information Act, as Attorney General Frosch states in his manual on the PIA, the MPIA is based on the enduring principle that the public knowledge of government activities is critical to the functioning of a democratic society, and that a government of the people, by the people, and for the people must be open to the people. And so we respectfully urge that the committee adopt the Senate version of MPI reform. Thank you for your time, and I'm happy to take any questions from the committee.
Mr. Love.
All right, good afternoon, Chair, Vice Chair Committee, Davon Love, Director of Public Policy, Leaders of People Struggle. I think the House has come a long way in the past couple of years on this issue of disclosures. I want to use the time that I have to refute what I find to be many of the arguments that have been made against the importance of increased levels of disclosure, in order to hopefully impress upon the committee the importance that more disclosure is better for public safety and better to address the issue of police brutality. So one of the things that has been raised is this issue of police officers being harassed both by people potentially going to their houses or on social media. First, I want to say that very few people are stupid enough to go to a police officer's house and harass them, given the amount of power that police officers have and have demonstrated. Additionally, there's no precedent for this. So information that has been made available about police officers, whether it's been in the media about forms of corruption that have been disclosed, whether it's in the form of the Gun Trace Task Force, there are many examples of specific police officers whose names have come to light, and none of the things that have been suggested would happen as a result of these disclosures has happened in any of those instances. Additionally, it's important to keep in mind that the purpose of disclosures is to provide the public the ability to assess what is happening within the police department in ways that the public currently does not have the information to do such. And so I think it's important, as the committee is making a determination as to not only the extent of disclosures, but also thinking about some of the potential barriers to disclosure, to lean on the side of more disclosure being good, because it outweighs the potential harms that are mentioned in this notion that police would be harassed by activists. And then finally, on this issue of false allegations of police officers and imputing the credibility of police officers. One of the things that has been frustrating to me in hearing this point made is that there's been no empirical evidence or any kind of systematic explanation as to the scope or nature of false allegations that are made of law enforcement. So it has really been our side who has argued for more disclosures that have empirical evidence as to the way in which the lack of disclosures have concealed the ability for the public to hold police accountable for forms of abuses. So again, as I've mentioned a variety of times in front of this committee, when you look at the Department of Justice report on Baltimore City's police department, or whether you look at some of the newer disclosures in the Graham report, you will find that allegations of misconduct that were housed under the unsustained category were needed for disclosure that would have been helpful to preventing many of the abuses that have occurred in the state of Maryland. So it's important that, to whatever extent possible, that ultimately the legislature passes a bill that allows for more disclosure so the public can serve its rightful place as the ability to oversee what's happening in the police department. And the public can't do that if it doesn't have access to the information it needs. And with that, I'll take any questions.
Thank you very much. Delegate McComas.
Thank you, Mr. Chair. This is for either Emmanuel or Mr. Love. I was looking at some of the testimony that was in the Senate on this bill, and the police department said a mandate of all charges, whether founded or unfounded, to be released is not allowed in any other profession. Do you know of another profession that would allow that?
So Delegate McComas, I think it's important that you and the committee is clear that this bill doesn't mandate disclosures. What this bill does is discretionary disclosure, which means that there's certain things that the agency is able to redact that they find that it's not in the best interest of the public or the person of interest in an investigation.
Well, they basically felt that that kind of the semi-open book would be allowed to besmirch the good name and reputation of honest working, hardworking police officers. They thought that the best types of cases that should be open to the public were alleged misconduct involving discharge of a firearm, use of force resulting in death or serious bodily injury, officer administratively charged committing a sexual assault, or engaging in dishonesty, committing perjury, making false statement, filing false reports, or destroying, falsifying, or concealing evidence directly relating to the reporting, investigation, or prosecution of a crime, engaging in prohibited discrimination directly relating to reporting, investigation, or prosecution of a criminal, or improperly using force against a member of the public. So it seems to me that those are pretty important that the public needs to be aware of and that should be reported, as opposed to, and those should be the things that are probably put into the statute, as opposed to just saying, well, you know, we're going to have some group decide what should or shouldn't, and they're going to figure out what's in the public interest and what isn't. I mean, this really goes to the heart of what we're all talking about, isn't it?
So Delegate McComas, I just want to reiterate one of the things I mentioned in my testimony, which is that even though in testimony, law enforcement has offered that as a potential issue, they provided no empirical or systemic information as to the scope of false allegations made against police officers. What we do have is a dearth of evidence about the ways in which officers who investigations go into the category of unsustained have concealed instances that should have otherwise been sustained. So until myself or others see such information, I don't know that I can trust the validity of the claim that this is a concern that should override the disclosure of these records.
You don't think that's what's enumerated there is more important than examining the internals of their personnel records?
I'm saying that there's no evidence of the false allegations against officers that would override the need for disclosures to address the things that we do have evidence are an issue.
I guess we're just on opposite sides. Thank you, sir.
Yes, ma'am. Yes, ma'am.
Just to add to that, you mentioned that no other profession shares unsustained or sustained complaints. And just to speak to that, there's no other profession that I know of that has the authority to deny people of their civil liberties or use excessive force. So it's exactly for that reason that we should be able to review all of these complaints and know exactly how officers and investigations are being handled.
Delegate Cox.
Thank you, Mr. Chairman and members of the panel. Real quickly to dovetail off of what Delegate McComas was just asking, but a little more specific for my question. Isn't it true that your comment, which I don't necessarily agree with, that that unsustained records should be released to, you know, because there's this history that they've been covered up or whatever. Isn't it true though that you're referring to sworn complaints that end up becoming unsubstantiated?
I'm referring to the Department of Justice report 2016 that was done by Baltimore City, the recently released Graham report, that within those reports determined that there were complaints that were made against police officers that were put in the category as unsustained, that a look at those investigations would determine by most people that they should not have been put in the category of unsustained.
And I'm not arguing with your reference to the report, but my point is those complaints were made under penalty of perjury. Isn't that true?
I'm not sure.
Okay. Well, my concern is exactly that, because at least I think some middle ground that we could discuss to tighten this up a bit is to ensure, and I don't think unsustained complaints should be released at all because they're unsustained. We don't do that in any category. We don't do it for social workers when they take our kids away, right? And to the point of Ms. Emanuel. But my greater concern, I think that we could possibly find some common ground on, is that if a complaint is not made under penalty of perjury and then is later unsustained, certainly we shouldn't be besmirching men and women in, with that carry the badge with those unsustained complaints that have nothing to do with any kind of truthfulness. Wouldn't you agree?
Delegate,
That's the possible middle ground?
Delegate, I think the evidence of the level of brutality and misconduct that have been reported and verified, I think are so overwhelming that I think the concern that you're raising about besmirching the character of law enforcement, I, again, have not seen, have not been provided with evidence that that is a problem. Well, I've only heard it said by law enforcement as a theoretical issue that may emerge. I don't have any evidence to suggest the extent to which that would be a problem.
Well, and I hear you, but this is changing everything. We're going to have algorithms now searching case search, if, with this law being passed. But here's my greater question, I guess, to see if we can focus in on this. Wouldn't you both agree that that's a potential middle ground, that we could come to agreement on this issue of saying, okay, if you want to release unsustained complaints, fine, but you know what? You got to make sure you're not lying. You got to sign this under penalty of perjury if you're going to make the complaint before we're going to release it, all over the internet. Isn't that a fair compromise at a minimum?
Well, Delegate, I'm not an attorney, but it's my understanding that false complaints or false testimony is already illegal. I don't know that we need extra protections to keep people from lying about what police officers are doing, especially since I don't know, as I continue to say, that this is such a problem that there needs to be a solution to it. I don't know that we do this with anything else, that we would propose adding something to solve a problem that we don't know the scope or nature of.
So I guess what I'm hearing then is that you wouldn't necessarily mind it because it's not a problem from your angle. It wouldn't be an issue then because people are already not supposed to lie. So it's not that big of a deal. And that would possibly be a potential.
I'm saying it's unnecessary. I'm saying it's unnecessary.
So if it's unnecessary, then it's not something you would greatly object to if we tweak that. Is that fair?
As long as it doesn't present any problems with the ability for people to complain. And I think there's reason to believe, because I think when you think about the way that the criminal justice system is operating in this country, there are ways in which criminalizing behavior inadvertently impacts people of African descent, people of color more than our white counterparts. So I'm always going to be reluctant to add additional kinds of criminal penalties in a situation like that. But again, the problem that you're citing does not strike me as something that should require us to go through these lengths to solve a problem that we don't know the scope of.
Well, I'm all for making sure truthfulness because I don't like criminal complaints that are false. I represent occasionally from time to time criminal defendants. And one of the things that I look very carefully at is that sworn affidavit statement that's made to law enforcement, because you want to make sure they're telling the truth, right? And you want to look at where they're not. And so I agree with you if it's not that big of a concern because, people are already being truthful. I think we could tighten this up and just make sure that if somebody felt uncomfortable, and I'm talking about an opt-in, I'm not talking about a force. If somebody feels uncomfortable signing something under penalty of perjury, but they still want to put it in, that's up to the department and how the form is made, or it's up to the state law and how it's allowed to be made. But at a minimum, if they opt in to signing under penalty of perjury, those would be the ones that would be considered for potential release on a case-by-case basis, rather than any unsworn, unsubstantiated. That's where you get this double conundrum where it just doesn't make sense logically otherwise. Is that something you think we could build a bridge on?
I just have a hard time wanting to exert energy in that direction, Delegate.
Even
I
if
just
it's
don't
like an
think-
opt-in. I mean, like I said, it wouldn't be forced. It would be like an opt-in. But we can talk more offline, but thanks so much for your time.
Delegate Griffin.
Thank you, Mr. Chair. And I wanted to, ask a question around Ms. Emanuel. You mentioned that this is the only profession that can affect people's civil liberties. And I push back on that a little bit. I think Delegate Cox made a good point about social services, how they can, go in and strip somebody's kids away from them. I think that's potentially could be a violation of civil liberties. Also, the National Guard, when they're sent in states of emergency, they're, in certain circumstances, like we've seen here in Maryland, we've seen that done. So do you support then unsustained complaints against social service workers and our National Guards folks being revealed to the public as well?
I have not seen anything where social workers or National Guard has been responsible for at least almost 200 murders right here in Maryland in just the last 2 decades. Police officers are the ones that are patrolling our streets every day, can pull you over and say, charge you with a crime or what's the word I'm looking for? Anyways, can say that you've committed a crime and then take you away. So you're right, social workers, National Guard are still agents of the state, but police officers are the ones that are in our everyday lives and have the ability to both deny people of their civil liberties and then in that same situation be able to say that they saw a weapon and then, physically harm or use excessive force. So this is a much more serious and something that we see on a more frequent occasion, but I don't think that means that social workers would be able or should have complaints, unsubstantiated complaints against them, but I think these are completely 2 different situations.
I have one clarifying question, what you just said. I wasn't aware that there was 200 murders by law enforcement in the state of Maryland in the last 2 decades.
That's correct.
There were 200 police officers charged with murder.
Not charged. I said people that were murdered.
Well, I'm not trying to go down this rabbit hole, but there's a difference between murdered.
It will kill.
Okay.
200 stolen lives. So.
All right, thank you.
Delegate Bartlett.
Thank you, Mr. Chair. My question is for Mr. Love. Thank you, Mr. Love, for being here, and thank you for your testimony. I just want to go back a little bit to your conversation earlier with, and I call it conversation because it kind of was a conversation with Delegate Cox. Isn't an unsustained finding an internal investigation based upon the record as it is presented?
Correct. It's an internal investigation.
Okay.
And so is.
Oh, okay. And is the only conclusion if a claim is unsustained that it is based upon a lie?
Unsustained, as I understand it, means, as it has mean, is that they found no conclusive evidence one way or the other. And so there's no action recommended as a result.
Right, but is that unnecessarily that means that the witness or the claimant is lying?
That's correct. It doesn't necessarily mean that.
Right,
correct.
Because aren't there several claims, charges, et cetera, that result in dismissal in a court? And are we to assume that every witness claimant statement is a lie?
We should make that assumption.
Okay.
And I think that's one of the, I think that if I could just say, I think that's one of the things that I think is an underlying thread, I think, in law enforcement's testimony against this. The kind of assumption that, police officers are above reproach and don't lie, and that those who aren't are more prone to lie. I think that's a kind of underlying notion that isn't spoken directly, but I think is undergirds the opposition to this.
I agree. Thank you, Mr. Love.
Delegate Malone.
Yes, this question is for Ms. Hopefully I'm pronouncing your name correct, Ms. Amuel. Am I pronouncing your name correctly?
It's Emmanuel.
Emmanuel, thank you, Ms. Emmanuel. Regarding your statement regarding 200 lives stolen, of those 200 lives that you're referencing, how many folks were prosecuted and convicted of, of murder, first or second degree?
I have to circle back, but I don't believe any of them have. I don't think we've had a police officer in the state of Maryland that has been convicted of murder, but I have to double check my notes.
Do you
There's
also,
one currently on trial in Prince George's County for the murder or for the death of William Green, but that has not. I don't think he's been convicted yet.
do you know how many of those 200 that you referenced there was a determination that it was a justifiable homicide?
I do not have that, but I can look into that.
Yeah, I'd appreciate that if you could send that to my email, and if you need that, it can be provided to you. Thank you.
Delegate Deborah Davis.
Whew. Hi, I'm glad to see Ms. Emmanuel and Mr. Love. Thank you so much for the work that you do. We wouldn't be here without your help, so thank you so much. It's getting tough to sit here. So is the death penalty legal in the state of Maryland? First question. What year was it outlawed? What is the role of the police officer in the street?
I would say the role is to be, as they say, to protect and serve. That's the slogan.
Talking about its original roots, and then it's slave patrols.
So, I mean, if anytime there's a killing in the arrest of a police officer, in the arrest of any person, we should be of concern, correct?
That's correct.
All right, that's all I have. Thank you.
Delegate Arakan.
Thank you, Mr. Chair. This question is for both Mr. Love and Ms. Emmanuel. Thanks for being here. Is there ever a time that either of you would consider an inappropriate use of force to kill someone ever? Does that ever happen?
To an appropriate use of force, you mean as like a private citizen, or you mean
anyone
simulating?
Anyone, a police officer. Is there ever a time that you guys see where there's a justifiable homicide? Do you think that that is a real thing?
I think self-defense is a real thing. If I'm talking about as a private citizen.
So not for a police officer, but for a private citizen?
Are you, I'm trying to understand, are you asking to simulate myself being a police officer and give a sense of what I think an appropriate use of force would be?
No, I'm just asking if you've seen cases where you thought, yeah, that there was no other option there, that guy had to be shot.
I don't think so, but I don't know that there means that there is not ever. I don't think it would be fair to say that there's never an appropriate use of force, but I don't know that I haven't heard anyone make that argument that police should never, ever use force.
Okay, and of the 200 cases that were referenced by Ms. Emmanuel, could you name a single one of those cases that you thought was justifiable?
Top of my head, no, I cannot. I would have to look back and look at every individual case and what were the circumstances around the situation. But of the majority that I have reviewed, I did not think that the excessive use of force or the death that resulted in that situation was necessary at all.
And who do we think is the most appropriate people to decide that? Do we think it's a grand jury who's looking at considering indictments, or do we think it's just the general public?
Well, I think that, especially since we're talking about, public disclosures of investigatory records, one of the things that I think it's important to note is that in a society where the collective American consciousness is draped in notions of white supremacy, one of the things that happens is that Black folks' lives are considered generally less valuable, less important to protect and take care of. And I think that impacts people's judgment. And, where there's a study that was done in 2014, The Essence of Innocence, that actually did a pretty comprehensive study on people's reactions to different races of people in dangerous simulations. And it determined that officers, it did this with police officers and the general public, both officers and the general public were assessed as responding more violently to things they perceived as threats from Black people. And this is something that has been, there's a series of studies that have substantiated this kind of sociological claim around Black people being more vulnerable. So I would argue to you, Delegate, that it's not just a question of particular uses of force, but it's the question of why is it that Black folks and people of color are overrepresented in those from whom force is used against. And I think that the answers are pretty clear, which is why we think more public disclosures will make departments more accountable to the decisions that they make and force them to think about what are the instances where force can be used, what are the instances where these kind of internal racialized biases are impacted the way that they use and determine the use of force. But I think all those things should be taken into consideration when we ask questions about particular circumstances.
I appreciate your comments about, working on racial bias. That's disgraceful. It's despicable, and we have to make sure it's not happening. I would just ask, if it's if the victim in the situation is someone who's Black and the officer is Black, is that also white supremacy?
Absolutely. So one of the things that's important for people to know is that, people of color can operationalize systems of white supremacy. I'll give a really basic example. When you think about chattel slavery and you think about the plantation system, there were Black slave drivers, right? There were Black people for whom a part of their role was to maintain the plantation system. And so, you can be Black and operationalize or carry out biases. And there are ways in which, and I've actually, folks who are familiar with the work that LBS does, that's one of the things we talk a lot about, is the way that there are Black folks for whom may be in positions of power that do things that do violence against other Black people that undermine the quality of life of Black people. And so that's actually something that, those of us who have really rigorously studied issues of how race has structured our society, that's one of the ways that white supremacy maintains itself, is through non-white people.
Very interesting. If you have any data on that, I would love to look at it. It's not really an area that I'm familiar with.
Absolutely.
These officers also being racist against Black folks, that's new to me. So I would like to look into that. Never heard that before.
All right, that appears to conclude the questions to this panel. We thank you both very much. We're now going to hear from Jerry Eaton, Clyde Bodewright, and Michael Davey. Mr. Eaton, need to go on video, please. Or Mr. Boatwright. All right, I see Mr. Davey. Let's go with Mr. Boatwright. That's fine. We'll start with Mr. Boatwright for 3 minutes, please.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Clyde Boatwright, and I'm the president of the Maryland State Fraternal Order of Police, and I represent over 21,000 law enforcement officers statewide. We're here asking for an unfavorable report on Senate Bill 178. We have some concerns as it relates to the secondary dissemination of these records if released. We feel as though that there could be blanket requests for disclosures on multiple fronts on multiple officers. There is no provision for expungement. We feel as though the people that ask for this information should be a party of the case. And they should sign a waiver that they're not going to secondarily disclose this information. There are some serious concerns as it relates to the safety of our police officers. I've heard testimony that there's no empirical data to support that. But if you look at the incidents that happened last spring, there were threats and also potential attacks on the homes of police officers that were implemented in certain cases that were high profile. So much so that security forces were staged outside of the police officers' homes, and the families were removed to a safe location. So there are some concerns as it relates to the safety of the police officers and their families. There should be a reasonable expectation that our officers, while out working and patrolling the streets, their families should be safe. So with that, I'll ask that this body give an unfavorable report for House Bill 178. And I'll stand for any questions.
Mike Davey, please.
Thank you, Mr. Chairman, Vice Chair. As Mr. Boatwright said, from the very beginning, the FOP has been opposed to any bill related to the release of unfounded, non-sustained, exonerated, or charges in which an officer was found not guilty of a trial board. Along with everything that Mr. Boatwright said, these are very serious concerns of us. I know Mr. Love made comments that there is no empirical data, but there also was no empirical data when a group of citizens showed up at President Ferguson's house at 11 o'clock at night by setting off fireworks and causing problems with his own family. And that's a major concern we have with law enforcement officers. And with all due respect to law enforcement officers, we know they have firearms. And if they feel their families are threatened, we have deep concerns as to what would happen there. It seems to me that one of the biggest arguments of the ACLU is they don't trust police departments to do a thorough investigation, and that's why they need these unfounded and non-sustained cases. Well, if that's really the true problem, there should be some formation of a committee or something to do an evaluation or review the internal affair process in each one of these police departments. Instead of having the police officer be the victim of having these unsustained cases come out to the public, maybe we should start looking at the competency of the internal affairs investigations themselves prior to the release of any documentation, and kind of wait and see. There are some police departments that do an outstanding job, to my detriment and my client's detriment, in doing internal cases. But if the groups believe that there is a problem with or a concern that these cases aren't being investigated thoroughly, there's got to be a process that we can form prior to the release of this information to ensure that the investigations are being done thoroughly and properly. We don't want to see the police officers become the victim of something that police departments are not, and I don't want to use incompetent, but are not making discipline a priority. For those reasons, we were obviously oppose Senate Bill 178. We do agree with one thing in Senate Bill 178. If a bill passes with the release of this information, we do support the idea of the technical infractions continuing to be personnel records and not be released. Thank you for your time.
Thank you very much. We're going to go now to Mr. Eaton. Jerry Eaton, please.
Thank you, Delegate Klippinger and members of the Judiciary. First, let me thank you for the opportunity to testify here today. I am Jerry Eaton with the Harford County Sheriff's Office, and I'm representing the over 300 members of the Harford County Deputy Sheriff's Union. We, as a collective, have very strong feelings about Senate Bill 178. This bill and bills just like it could potentially have very far-reaching and unforeseen consequences that could run through law enforcement ranks and potentially adversely affects the communities that we serve. The section of Bill 178, which is most alarming to me and those I represent, is the ability and the intent to release the unsustained allegations of misconduct to basically anyone who requests them. A not guilty finding would not be admissible in a civil or criminal trial, so why should they be released to the public at large? The potential for abuse by those who don't support the police is just staggering in my mind. Many police agencies throughout the state, mine included, have policies in place that require all complaints to be fully investigated. In many of these cases, the complaints are completely unfounded. They've been filed by someone who has an axe to grind against a specific law enforcement officer or agency. If Bill 178 is to pass, unfounded, exaggerated, baseless complaints, they could just destroy the reputation of honest, hardworking police officers who are simply doing what they can to keep their communities safe. As was mentioned by Delegate McComas and Delegate Cox, any other business in the world, unfounded complaints are kept strictly confidential. For these reasons, on behalf of the Harford County Deputy Sheriff's Union, I'm requesting that the members of the Judiciary Committee vote unfavorably for Senate Bill 178, or at the bare minimum, amend Bill 178, removing the section that allows for the release of unfounded complaints. Thank you.
Thank you very much. Are there any questions from the committee? We'll start with Delegate Arakan, please.
Thank you, Mr. Chair. Good to see you all here. This question's really targeted towards Mr. Boatwright. If you were listening to the previous panel, it was justified, this bill's justified by what they believe is an endemic situation of white supremacy in our police force. And it's apparently not being committed by just white folks, but is apparently maybe even more so being perpetrated, according to the previous panel, by our officers of color. So I just wanted to give you an opportunity, if you'd like to touch on that, so that we could maybe set the record straight, because I'm not sure we're getting a full picture of our men and women of color that are in uniform right now.
Yes, thank you, Delegate Arakan, for that question. I take exception to that categorization that, you know, African-American officers and officers of color are perpetuating some form of white supremacy. I hate that term. I hate the practice of white supremacy. As a Black man and as a law enforcement officer, I hate both of those categories. And hate is a very strong word that's never used freely in my vocabulary. But in this case, as a person that has been a police officer for going on 21 years, have served the same community that I grew up in, assigned to the same community that I grew up in, where some people had it they had a question: do they call me Officer Boatwright or do they call me by my nickname because they knew me personally? So to categorize that as a man that has policed my community, and to speak for others like me, because I'm not the exception. You know, I'm not the one that, I'm not the only person that has done this. But to categorize us as being a part of white supremacy is problematic. We're sitting here on the 84th day of the year with 65 murders in the city of Baltimore. But there's not a discussion about that. So I just think that, you know, we should really focus on, you know, police reform. I think that this body is doing an excellent job on addressing that. It's something that we can work on and continue to work on. But to say that we're part of white supremacy is a problem for me.
Thank you very much. Thank you, Mr. Chair.
Delegate Wanika Fisher.
Thank you, Mr. Chair. Thank you, gentlemen, for being here today. I just had a question about, I understand the concerns, and I think this is something this committee, and I'm sure the Senate, we all struggle with. You know, how do we get a sense of an officer's actions, inactions, behavior pattern without seeing all of it, without seeing your sustained, unsustained, unfounded? You know, the incident in my home county, you know, that officer with, you know, had 18 complaints before, you know, he shot Mr. Green, you know, $20 million settlement of, you know, your handcuff in the front seat, and it was, you know, a murder. So how do we prevent, rather than always, you know, I think it's easy for, not easy, we can really all kind of grapple with, someone did a bad action, what's the accountability going to look like, right? We can debate what due process looks like, what the punishment should be, what the outcomes are, but how do we prevent on that end without seeing everything, without seeing a pattern of behavior and issues? So that's really my question, and it's been in my mind and my question for the last year, you know, under my vice chairwoman's leadership of those many conversations on the work group, and just every work group I've been on my local county work group, but it's still something I really, really struggle with. So if you all could address that, I would appreciate it. How do we know to prevent if we do not see everything?
So if I may, I think one of the keys is, in other bills that we've seen this year, are requiring police agencies to have this early warning system. And it just can't be words, you know, on a paper or in a bill. It has to be meaningful. police departments know the complaints when they come in. They have to be held more accountable. Clearly the officer does, but the departments themselves have to be held more accountable to what's going on with their own individual officers, whether it be through their first line supervisors recognizing there being a problem, whether it be internal affairs recognizing there being a problem. At some point, there has to be some responsibility put on the department other than just say, yeah, we called him in and we think he's okay. They have to do more. Baltimore City has a new program over the last couple of years, their health and wellness section by Director Haran, who's done an outstanding job with this. He brings people in, whether they think it might be an alcohol issue. You get 1 or 2 complaints regarding discourtesy or use of force. He sits down, he talks to them, but sometimes even they miss it. But there has to be some responsibility of the police agency themselves to look at this and recognize the problem, as opposed to allowing an officer with 15 unnecessary force complaints or excessive force complaints in a year. I think instead of having just dumping all of this information out, there has to be a mechanism for a group or somebody through maybe even the Maryland Police Training Commission, a subcommittee, to look at certain officers and what is going on causing these issues, instead of just doing a dump of this information on personnel information to the public to be used for whatever there is. So I think there can be a mechanism for this, and it clearly could have public involvement, because I believe in some of the bills, they're talking about adding many, many more citizens to the Maryland Police Training and Standards Commission. So I think there could be a mechanism for that to happen and give the early warning system much more teeth than just the words on paper.
All right. Thank you. We'll go to Delegate Ron Watson now.
Thank you, Mr. Chair. And Mr. Boatwright, thanks for your previous response. I don't know how the language got misconstrued, but the intent of the prior person was basically to say that in structures of power, there's been a history of those in power using blacks to keep other blacks in control. My question is for Mr. Davey and Mr. Eaton. Real simple question. Do you believe in expungements? Do you believe that someone who has had a criminal record should have those things on the record that they weren't formally charged with expunged?
Absolutely. I mean, if you're charged and found not guilty, or it's now processed criminally, absolutely it should be expunged. It should not be on your record. And in fact, in those cases, they're expunged immediately. You don't have to wait 3 years, even as you do under the current law and in the Senate Bill I think it's in Senate Bill 627 that Senator Carter was talking about.
Well, let me be specific. We had this thing related to partial expungements in the unit rule. And when we had the police officers come and testify as to whether or not those items that an individual was charged with but not convicted should remain on their record, their statements were that they must remain on the record. They provide a historical perspective of an individual. It is a risk to the police officers if they're seeking to apprehend someone and they don't have that information. And the reason that's important is because the whole purpose of everything we're doing is to clear up the misperceptions that law enforcement officers are treated different from regular citizens. And the reason why we're having this discussion about these unsustained complaints is because there has to be an even playing field. Now, even though you have something that's unsustained, it could pose a history of being able to tell how a certain officer has acted over time. And you can make the same argument for someone who has been arrested and has a series of charges, but has only, been criminally charged on 1 or 2 of those things, and they remain on their record. And so that's the reason why I bring this up, because there has to be a fair standard across the board for the citizens and for law enforcement. I would be 100% in your corner that we don't need to have the unsustained pieces in that record. If one police officer said, Mr. Watson, Delegate Watson, I support partial expungements. I support, getting rid of that union rule, but that didn't happen. And that's why I have an issue with what you guys are asking for, and I'd like you to respond.
Well, I think I understand the police officer on the streets concerned when they're making an arrest or going to serve a search and seizure warrant, an arrest warrant, wanting to know all the history. Expungements are there for a reason. And I also understand a police officer's position when he's found not guilty or it's not sustained to have it removed. I think there probably is a middle ground here. I think there possibly could be a middle ground in that while you can expunge unfounded, non-sustained, exonerated on certain things, but maybe not others. We're talking about the Senate bill is a 3-year expungement. The current LEOBR is a 3-year expungement. It would be hard for me to say there'd be a pattern of practice of a police officer being or using excessive force when he has one, gets it expunged 3 years later, he gets another one 5 years after that. That, to me, that is not a pattern and practice of excessive force on the police officer. I think 3 years is sufficient. It's not 1 year. It's not immediately, as it is a criminal case right now. So I think there could be a middle ground. We would be open to that discussion if we were to get to that point. But where we are today is everything is being disclosed. We've gone from, the 3-year expungement to everything. And there's really not been a lot of discussion of trying to negotiate something in the middle.
If I could just piggyback off of that a little bit, going back to Delegate Watson's statement about an even playing field, there's no other profession in the world where unsustained complaints are released to the public. Only in law enforcement does that happen. I do agree with expungements 100%, but I feel like if a complaint is not sustained, it should not be released. I'm also going to agree with Mr. Davey in that the agencies and the first line supervisors have a responsibility to look at these patterns of conduct and these patterns of complaint and act appropriately when the need arises.
And you will now, to piggyback on the previous two speakers, Delegate Watson, you'll have the labor attorney for the Maryland State Fraternal Order Police. You'll have Harford County Sheriff's Office on record, and you'll now have the Maryland State FOP on record as saying we do support expungements.
All right. Let's go now to Delegate Cardin committee. I am going to pass over the chair now to the vice chair. She's going to keep us going through the next several bills, but we'll go to Delegate Cardin now and hear from him. Delegate Cardin.
Thank you very much, Mr. Chairman. Thank you all very much for testifying. Actually, Delegate Watson covered everything I was going to ask, except I would just hope I understand why you have the position you have, and why you said what you said to answers to his questions. I would just hope that we would see you not just say you support the idea of expungements and partial expungements, but that you would actually test in favor of those bills, which we have now heard year after year after year. And I don't think we've ever had the FOP or the state or the police or the sheriffs come in and testify in favor of the bills. So I would just say that might be something that you want to consider doing. And I look forward to hearing that from you guys in the future.
Delegate Jones and then Delegate Conway.
Thank you, Madam Vice Chair. I appreciate the comment that Mr. Davey made regarding departments evaluating the conduct of their officers a little bit better. But my initial question is really for Mr. Eaton. You mentioned a little bit that when you were talking about the unsustained complaints, my question is, what is the process for a local sheriff's department like yours internally? I know that there are counties in Maryland with departments smaller than yours, and if there's a complaint of misconduct, it's all handled internally. We don't know what happens in those investigations. We want to believe that they're thorough, but if all of the officers know one another, because it's a small department. I'm just wondering, what are the odds that sometimes some of those investigations come back unsustained, when really there may be a little bit more to it? Can you explain just briefly for me, I guess, what your process is internally and why you feel like it's, I guess, a fair process?
Sure, I can tell you that any complaint that's received specifically to my agency, the Harford County Sheriff's Office, it has to be investigated fully. We're not allowed to like blow off a complaint and tell them to not worry about it. It goes to our Internal Affairs Division. From there, either the Internal Affairs Division will handle the complaint, or lesser complaints may be delegated out to supervisors to do thorough investigations. These are all reviewed and approved by command staff. We put gag orders in place. Deputies are not permitted to speak to other deputies about any investigation that's going on, for penalty of other, they can be charged with those things administratively. So I would argue that our complaint process is very, very fair. I feel it's very thorough. And I feel that we have some of the best people in our agency in internal affairs to handle these complaints.
Thank you.
Delegate Conway.
Thank you, Vice Chair. Thank you, committee. Mr. Davey, I'd just like to ask you this question, and I appreciate you guys stating that you would be in favor of partial expungements. But as you probably know, there's a level of difficulty with the partial expungements due to the lesser charges that are thrown out are locked in by the higher charge that a person is pleaded to. So while you're making it, I'm trying to be as nice as I can. You're making it appear that you want to work with the situation on partial expungement, and you're in support of it, and you're sympathetic to it. You know, legally, we have a different kind of problem. So would you just acknowledge that?
No, there's absolutely an administrative problem on how all that works. There is no question. But I don't think that's something the FOP or law enforcement can fix. I think that's more of a court administrative issue.
Right, but I wanted to acknowledge you in trying to work with us.
Yes, we would be according to.
That's why I brought that up. Thank you so very much.
No problem, sir.
Thank you. And seeing no further questions, that concludes testimony on House Bill 178. I'm sorry, Senate Bill 178. Moving on to Senate Bill 419. And I believe there's just one person, Mr. Hansel, and he's coming in. He's taking a minute to connect to audio. I don't know, Dylan, if that means there's a problem or. Okay, Mr. Hansel, you are up. And if you could just turn your video on, please, and you'll have 3 minutes on Senate Bill 419.
Thank you very much. My name is Kerry Hansel. I am a civil rights lawyer. I've had the pleasure of testifying previously before the committee, and I am also the chair of the largest group of civil rights lawyers in Maryland, the Civil Rights Section of the Maryland Association for Justice. Senate Bill, I'm sorry, are we here? I apologize, I'm looking at my notes. Is this 419 or 626?
Yes, 419.
Okay. Senate Bill 419, I apologize, I'm signed up for a couple today. Senate Bill 419 is a bill that we very much support as civil rights lawyers. It involves the strictures to be placed on no-knock search warrants. As Delegate or Senator Carter mentioned earlier, House Bill 670 also addresses no-knock warrants and in many ways has stronger protections. So if we were here in a conference to discuss the two, I would very much be in favor of House Bill 670. Having said that, something has to be done on no-knock search warrants, And there are significant protections available in the Senate Bill 419. And so we would urge a favorable report. With that, I'm happy to answer any questions or discuss any of the distinctions between the two bills. I wanted to keep my testimony brief in light of the fact that this committee has heard my testimony on these points in the past and also has heard from many victims whose plight I will briefly remind you of, who would like to see the types of changes brought by this bill.
Thank you. Are there any questions for Mr. Hansel? Seeing none, Mr. Hansel, you can sit tight. That concludes the testimony on Senate Bill 419, and we will move on to Senate Bill 626. And we'll begin with Mr. Hansel, who is favorable with amendment.
Thank you. 626 is a matter that it is urgently important that this committee consider a point that was amended into the bill in JPR, and that is in section 10801B. The definition of excessive force as used in this bill is in the current draft pursuant to the amendment that got into it in committee on the Senate side is grossly unconstitutional. There is a significant issue. And if you look at the language there, excessive force is defined as force that exceeds that which is necessary to gain compliance or control a situation. The use of force without more to merely gain compliance or control a situation is unconstitutional. The Supreme Court long ago in the Garner case ruled, for instance, you can't shoot a fleeing felon in the back. That is the type of force that would be justified under a standard that authorizes force to gain compliance or control a situation. Imagine some other examples. If a citizen is seen jaywalking outside of the crosswalk at an intersection, for instance, it would not be excessive force under this definition to use force to force the citizen into the crosswalk, to use force against a citizen to gain compliance if the citizen just wasn't going to go into the crosswalk or didn't follow an order. So that might mean pepper spraying, it might mean tasing, because there is no proportionality requirement in this bill as currently drafted in this section as there is in the House bill. Likewise, in the case of gaining compliance, for instance, imagine a single officer in a crowd control situation where there is no risk to the officer, no risk to anyone in the crowd. He's merely trying to disperse them, and they don't comply immediately with his order to disperse. Now, it is not excessive force under this definition as drafted if he then opens fire, whether it be with a taser, mace, a firearm, because it is not excessive force to use force to merely gain compliance. And there's nothing else attached to that. So no other requirement, for instance, for the officer's safety to be at risk or an individual's safety to be at risk. And it is also not excessive force to merely use force to control a situation. The purpose and goal of setting a state court standard to join the other 41 states who have a standard here is to create a higher standard than the constitutional floor. This definition, if allowed to pass, would in fact grossly lower the standard and take the standard from one that is in effect to protect life and safety of police and others to one where force can be used merely to gain compliance or control a situation. And under the definition in section 10801B, there is no limitation on the type of force that could be used to gain compliance, the type of force that could be used to control a situation, or the proportionality under those circumstances. So as written, this one section, which was the result of a single amendment in JPR, would be unconstitutional, number one, and number two, it would defeat the purpose of the bill. And and House Bill 670 has an excellent standard which does none of those things. So I would urge this committee, if this is going to receive a favorable report and leave the committee at all, to please amend section 10801B So to include the definition of excessive force that is in House Bill 670, that is in section 3-524 there, if we're referring to what will be the code sections. And there's an excellent definition there. Time doesn't permit me to go through it in detail. But without that amendment, this is grossly unconstitutional, will not survive review by the courts. And even if it would lower the standard below the constitutional floor. So for that reason, I would urge an amendment. And I'm happy to answer any questions because I think this is a critically important issue for the life and safety of Maryland citizens.
Thank you. Are there any questions for Mr. Hansel? Seeing none, thank you very much. We have several people signed up as unfavorable: Joe Spielberger, Jerry Eaton, Clyde Boatwright, Michael Davey, and Eric Roby. So they will all be let in. And Joe, you can begin and you have 3 minutes. How are you?
I'm doing well, Vice Chair. Great to see you. Good afternoon, everyone. Vice Chair Atterbury, committee members. I'm Joe Spielberger, here representing the ACLU of Maryland alongside the organizations that make up the Coalition for Justice and Police Accountability. And we are regretfully here in opposition to SB 626. I certainly echo everything that Mr. Hansel just said about the unconstitutionality of this new legal standard based on the Senate's amendments. We certainly appreciate the work that this committee did to amend onto the Speaker's bill so much of Delegate Davis's bill, HB 139. One additional point I wanted to make quickly about the legal standard is that it also says that an officer only may not intentionally use excessive force, which is a higher bar to reach to show excessive force than currently exists under the Graham standard. And lastly, one good thing that we like about what the Senate did is incorporate need data collection and reporting requirements for law enforcement agencies. So that includes things like looking at the type of force that is used in different situations, personal demographics against people whom force is used, and those types of data that will just lead to better policy in sessions ahead if we get a better understanding of how force is used. So moving forward, again, echoing what you just heard, I would urge this committee to stick with the legal standard and the strong language that is currently in the Speaker's bill and include that data requirement as well. So thank you very much.
Thank you. Mr. Eaton, 3 minutes.
Yeah, again, I'm Jerry Eaton, Harford County Sheriff's Office, Vice Chair Atterbury, and the Judiciary. Thank you again for your time. I'm representing the 300 members of the Harford County Deputy Sheriff's Union, respectfully asking you to not support House Bill 626. This bill and other similar bills could be some of the most impactful and deadly pieces of legislation ever proposed for law enforcement in this state. In a 2018 study by the U.S. Department of Justice, in the United States, there were roughly 260 million citizen contacts with police. Of all those 260 million citizen contacts, roughly 3.3% involved any type of force whatsoever. Of those, 2.2% of them were simply handcuffing a detainee or an arrestee before taking them to jail. So this means 260 million citizen contacts in 1 year, only 1.1% of them involved any kind of use of force. Subsequent interviews by those who had force used against them revealed that 30% of those individuals thought that force was necessary based on their own action. So I feel like the issue I'm talking about with de-escalation specifically is not the widespread problem that the news media wants us to believe nationally. Obviously, the purpose of my testimony is here is not to educate this committee on police use of force encounters. I'm just here to try to express how dangerous Senate Bill 626 could be to police. All police encounters, like I just mentioned, the officer's response is almost always dictated by a suspect's action. So knowing this, law enforcement officers train continuously to become proficient in instinctual responses. Me personally, I've been a trainer and an instructor at my agency for the past 15 years in de-escalation techniques as well as defensive tactics techniques. And I can say without question, de-escalation will always be the preferred outcome. In most cases, it is the outcome, and it is what occurs to bring situations to a safe conclusion. However, I can also tell you confidently that de-escalation is not always possible. One of the primary axioms of law enforcement is that action will always be faster than reaction. When an officer has to react to a suspect's assaultive behavior, that officer will literally have mere seconds to make what could potentially be a life or death decision. If these precious seconds are spent toggling through an escalation continuum in their mind, it could almost certainly lead to the death of the officer or the death of a community member who the officer was trying to protect. Moreover, requiring law enforcement officers to use unrealistic de-escalation techniques, such as waiting a suspect out or giving him time to move about in a safe space, or to let them just move freely, could undoubtedly put the officer at a tremendous disadvantage, not to mention it could result in grave danger for the community that's being served. Yes, we can obviously cite examples of officers making mistakes as it relates to use of force. However, as I mentioned before, the examples of these mistakes are microscopic in the grand scheme of things throughout the state of Maryland and the country as a whole. And any officer who does engage in gross or excessive force, they're not and they should not be protected from any personal or professional accountability, in my opinion. But in closing, I am just going to request again on behalf of the members of the Harford County Deputy Sheriff's Union to strongly request the members of the judiciary to vote unfavorably for Senate Bill 626. Thank you.
Thank you. Clyde Boatwright.
Good afternoon, Madam Vice Chair. Again, my name is Clyde Boatwright, President of Maryland State Fraternal Order Police. So there's a difference, and we ask that, we return an unfavorable report for Senate Bill 627. And we think that the Senate got it right as far as the definition of excessive force. However, the criminal penalties attached to that becomes problematic for police officers, because you could very well, and I'm quite sure our attorney Mike Davey will give you some examples, you could very well have used excessive force by definition under police policy, but still it didn't rise to the level of an assault in a criminal case. So I think I understand the legislature's idea to try to differentiate between an assault and excessive force, because in some of the cases that are referenced, people feel as though that what they see on camera is an assault versus what's defined as an excessive force complaint. And this based on optics, is based on the different angles and views of the camera. So there could be a way to differentiate that, but that's already covered under Maryland law, under the criminal statute. So if you feel as though a person assaults, whether it's a police officer or not, if a police officer commits an assault while in uniform, there's a criminal law for that already. So I'll just give you an example of why we think that this particular bill would not be good for policing. If a police officer sees a purse snatch and he chases down the suspect, and once he gets to the suspect, there's a fight. If we go to the other standard that was written in House Bill 670, the other standard, people could look back and say that the police officer did not have to engage and use force because it was just a purse snatch, and that the person that was the victim was not injured. And so if we get to a position where the officer had to use force, and we can retroactively look back at all of the circumstances that led to that, then we're now Monday morning quarterback, and our police officers won't be effective. So with that, we like the definition in 627, but we would like to urge an unfavorable report based on the criminal penalties attached. And thank you.
Thank you. Michael Davey.
Thank you, Madam Vice Chair. As Mr. Boatwright already stated, the FOP has the great concerns and opposed to the bill as written by adding additional criminal penalties for officers. An intentional use of excessive force is already covered in the criminal code. First-degree assault, second-degree assault, reckless endangerment, any number, murder, manslaughter, any number of charges can already be placed if an officer intentionally uses more force than necessary. The failure to intervene and failure to report are extremely high-profile cases within law enforcement agencies, and if they're not, they certainly should be. I would argue that I know in many of the larger police departments, if you fail to report an intentional use of excessive force or you fail to intervene, you're looking at administrative penalties too, and including termination of your employment. Police departments take that very serious already. And obviously there could be some unforeseen circumstances when you charge an officer with that, then state's attorney would have to prove that they had actual knowledge. It can make it very difficult, and I think the laws in place already take care of that. As Mr. Boatwright was stating, I think Mr. Hansel, when he reviewed 10801B, he talked about a lot, but he didn't talk about probably the two words that are most important in that entire bill when it comes to excessive force, and that's excessive force means that an objectively reasonable law enforcement officer. That is the standard in Graham v. Connor. It basically says that you have to look at that moment based on the totality of the circumstances as to what a reasonable officer would have done. It's not Monday morning quarterbacking by somebody sitting in their office, as Mr. Boatwright said, months and months later, determining, well, maybe he could have done this, maybe he should have done that. The key is the objectively reasonable officer. And by keeping that language in the bill that Mr. Hansel never even spoke about, that takes care of the issue when he talks about controlling a situation. If an officer is at a scene and he's trying to control a situation and he says, well, I can't control this, I'm going to discharge my service weapon. Clearly, that's not likely to be the same action of an objectively reasonable officer. And that, therefore, this definition or this standard is what the General Assembly should go with and stay with, as opposed to changing it to something of proportional or necessary and proportional, where the totality of the circumstances may not be looked at that moment of time. And for that reason, we're opposed to the bill as it pertains to the criminal aspect, but we are in favor of Section 10801B as it pertains to the standard of force review. Thank you.
Thank you. And finally, Eric Roby.
Thank you, Madam Vice Chair. And I guess when you go last, everybody's pretty much said everything there is to say. So I want to thank Corporal Eaton and Mike Davies and Clyde Boatwright for touching on the main points of why the sheriffs and chiefs have major concerns with this piece of legislation, Senate Bill 626. The only thing that I want to add that they did not hit on is recruitment and retention. When you're looking at a piece of legislation coming forward that puts new criminal penalties on duty to intervene, use of force, and failure to report, you're going to get police officers and sheriff's deputies throughout the state of Maryland that are going to be, to say it best, hesitant to go into that situation where where an innocent person's life is in jeopardy, and to be able to take the effective action they need to take for fear that not only are they going to become hurt or endangered, that they're also going to lose their freedoms and be looked at as a criminal because of that. So when we're looking at recruitment and retention around the state of Maryland, as you can see, most agencies are having a challenge hiring good police officers. And I think that's what the purpose of all these police reform bills is to make sure that we have good police officers that we've hired throughout the state of Maryland. And legislation like this just does not accomplish that goal. It doesn't, meet that objective of bringing officers in that are that want to do the job every day and want to be proactive, good police officers in the state of Maryland. So for that, Madam Vice Chair, we'd urge an unfavorable report on 626.
Thank you. I see Delegate Conway has a question.
Yes, thank you, Vice Chair. Thank you, panel, for coming in. This is for Mr. Davey. I was going to ask a question about what the objectively reasonable law enforcement officer might think in reference to a person that was, let's say, 3 feet away from him with a knife. But then listening to further testimony, could it be said that an officer that tells a person, let's say, to get down on the ground or show their hands and the person turns their back, the officer could take that as being an act of aggression, like the person might be trying to hide a weapon or is going to use a weapon momentarily? Is that a way that this could be interpreted?
I would hope not. I think police officers get much better training than that. The mere fact that somebody turns away, I think a reasonable officer would not discharge their firearm at that point. He may give verbal commands to turn around and show his hands prior to taking some form of physical action. And I think their training would kick in and to permit them to do that. I think you can't look at every case exactly the same way. I guess and that's why you have language in this Senate bill that talks about the totality of the circumstances. If this individual just fits the description of someone who just robbed a convenience store with a handgun, and you're fairly confident that this is the individual involved, you may treat it a lot differently. And that's why you have to look at an objective reasonableness based on the totality of the circumstances. A knife 3 feet away, again, that's a training issue. The way officers are trained now, somebody gets within 20 feet of you, I think it's 21 feet is the zone of influence. And if they're attacking you within 21 feet of a sharp object, that rises your training to the point that you likely could use deadly force if you need to be. But again, those are training issues more than anything else, sir.
Thank you very much for that explanation. Have a great day.
You too, sir.
Seeing no further questions, that concludes the testimony on Senate Bill 626. Moving on to Senate Bill 627. We have a handful of unfavorables signed up. Yannette Emanuel, Jerry Eaton, Davon Love, Clyde Boatwright, and Michael Davey. So there's just a couple people that need to come in, but we'll start with Jerry Eaton when you're ready. And this is 627.
Yes, thank you again, Madam Vice Chair. In reference to House Bill 627, I'm looking for an unfavorable report or an amendment. I want to start by commending the Judiciary Proceedings Committee for their bipartisan effort when they created Senate Bill 627. I certainly believe the Law Enforcement Officer Bill of Rights is being demonized under false pretenses. There are some elements of this proposed bill that I think will allow for due process, and I thank you for that. That being said, on behalf of the membership of the Harford County Deputy Sheriff's Union, I have a major concern regarding Senate Bill 627. One of the very important elements which needs to be amended pertains to sworn higher-ranking law enforcement officers used on a trial board. In this bill, the proposed 3-person board will already encompass 2 independent civilian members. What the proposed trial board lacks is the inclusion of a member of the accused officer's agency who has a similar perspective, experience, and rank as the accused. As with any business, tenure, employment, time, and rank are going to create different perspectives and a different view of a particular situation. This is no different in the field of law enforcement. A law enforcement corporal may have a very different experience level than that of, say, a law enforcement lieutenant or captain. This will undoubtedly affect the decision-making process on a trial board. Allowing a higher-ranking member on the board would also not preclude the chief or the chief's designee from participating. This could limit the board members from truly examining the totality of the circumstances objectively. Therefore, while I think it's appropriate for this committee to vote unfavorably on Senate Bill 627, on behalf of the membership of the Harford County Deputy Sheriff's Union, I'm requesting that the committee amend this bill and allow for an equal ranking member on the trial board of any accused officer. Thank you.
Thank you. Clyde Boatwright.
Again, good afternoon, Madam Vice Chair. Jerry hit on a lot of the same points that I was going to hit on. This committee did an outstanding job. When I say this committee, the House Judiciary Committee did an outstanding job on 670 as relates to the discipline piece of for police officers. And while JPR on the other side, on the Senate side, did great work. The higher rank issue is a problem for us. And we all know how we got there, how we got here. Our police chiefs and sheriffs have had too much power and authority and have failed to execute that power and authority, which has led to the attacks on the law enforcement officers' Bill of Rights. So we simply ask for due process. We think that a member of equal rank, a member of the public that has been trained, and a administrative law judge would be sufficient to provide, to oversee a trial board and police discipline. We think all cases of allegations against a police officer should be reviewed because we don't want to set a standard where we have 148 different policies as it relates to discipline of a police officer, especially for those complaints that don't involve the member of the public. So with that, we will ask that Senate Bill 627 be returned with an unfavorable report. And I'll stand for any questions, and I thank you.
Thank you. Michael Davey.
Thank you, Madam Chair. This bill's too long to go line by line, trust me. But there are some good parts of this bill, and there are some parts we obviously don't support. As Mr. Boatwright and Deputy Eaton commented, the makeup of the trial board in this Senate bill It's one higher ranking member and 2 civilians, which just is not a fair makeup of the actual duties of that individual officer at the time. As Mr. Boatwright stated, we would like somebody of equal rank, an independent third party, either being an administrative law judge, a retired judge, or an arbitrator, and a civilian. One of the biggest portions that's missing in Senate Bill 627 is really any civilian oversight. And I think that's one of the reasons we got here, and the elimination of the LEOBR is there is no civilian oversight other than having 2 civilian members sit on a trial board. House Bill 670 has a clear and distinct policy and procedure in place as it pertains to the charging committee or the police accountability board, which we think is a much better way to go with this. And we are open to that completely. We do have obviously some issues that we've discussed in prior committee meetings with House Bill 670. Whatever bill comes out, we would like it to be a statewide bill that covers all discipline, not just discipline made by the public. And it should have a detailed list of what is required to be done through the investigation, the charging, and the hearing board itself. Neither bill, either 670 nor 627, has any provision for a complaint to show cause, meaning if the agency violates one of these procedures prior to going to trial board, we could go to circuit court. That is somewhat problematic for us, but really the only way to be fixed is to make sure that we have detailed structure in the bill as it pertains to all parts of the disciplinary process, from the investigation to the charging to the trial boards and the appeals. And just looking over this, the other portion, we do like parts of the statute of limitations in 3108. However, one of the provisions basically says it can go on as long as somebody thinks it's reasonable, which just isn't right. There has to be a time limit on when these investigations are done and an officer is charged. And that is one of the biggest problems. In an earlier bill from the ACLU, they testified earlier today about the Panera case, and it took 2 years from the date that officer was convicted of tampering with evidence to take him to a trial board. That had nothing to do with the police disciplinary system. That had to do with the incompetency of the Baltimore Police Department to put that on a trial board schedule. He could have gone to a trial board 10 days after his conviction. They waited 2 years. That's not the police officer's fault. That's the department's failure to prioritize police discipline. And we just want to make sure, as Mr. Boatwright stated, that we have a fair due process system that's in place for everyone statewide on all sorts, on every complaint that could be made. Thank you.
Thank you. Yannette Emanuel.
Well, good afternoon again, Vice Chair Atterbury and members of the committee. My name is Yannette Emanuel, and I'm here on behalf of the ACLU of Maryland and on behalf of the Maryland Coalition for Justice and Police Accountability. We've heard a great deal about what SB 627 does, so I will focus my remarks on the ways in which the bill fails to fully repeal LEOBR and establish real community oversight. When it comes to accountability, the problem is not that police have inadequate mechanisms to discipline officers, and the problem is not that there is a shortage of administrative or bureaucratic systems for accountability. The problem in law enforcement is the unwillingness to discipline their own. This is why communities need tools to hold departments accountable. Unfortunately, as amended, SB 627 restructures trial boards and makes them the final decision maker on whether an officer can be punished. The only difference from the current LEOBR is that the composition of the trial board now includes 2 civilians. However, there is no process spelled out regarding how civilians would be selected. In addition to that, the failure of trial boards to discipline abusive officers is the reason that we're here today. And as amended, SB 627 merely plugs in civilians into a failed structure. And as amended, SB 627 also reinstates some of the worst LEOBR provisions. The bill, 1, allows an officer to expunge misconduct records after 3 years, prohibits the use of misconduct allegations in administrative or judicial proceedings, and bans police departments from requiring officers to disclose their personal assets. Worst of all, SB 627 fails to enable the possibility of real external community oversight boards with the ability to investigate misconduct, adjudicate discipline, and have community control over police departments. As the committee knows, the language which was in 3-114 on page 21 through 22 of the marked up bill was removed by JPR in a close 6-5 vote. Senator Smith, Carter, Hedelman, Sidnor, and Lee all voted to keep this language in the bill, and we would like to see the committee reinsert this language as it is critical to accountability. According to research conducted by and published by the Seton Hall Law Review, some of the key components of a civilian review board are having a broad scope to review complaints, independent investigatory authority, ensuring discipline sticks. And in addition to that, according to the National Association of Civilian Oversight of Law Enforcement, police oversight can benefit not only the individual complainant, but also the larger community, including police and the sheriff's department, and even elected and appointed officials. So instead of restructuring the bureaucracy in policing, we urge the committee to adopt the community oversight language and ensure that that officers don't have more rights than any other public employee has. And that I will urge the committee to adopt that language. Thank you.
Davon Love.
All right, Vice Chair, Committee, this is Davon Love again from Leaders of a Beautiful Struggle. Those of us who've been working on the issue of police accountability for many years, the central question that many of us ask ourselves is, how do we give community more control over law enforcement? When you look back at documents of many of the historic traditional civil rights organizations, whether it's the NAACP, whether it's the Southern Christian Leadership Conference, whether it's the Congress of Racial Equality, when you look at their policy documents, particularly that emerged in the middle and late 60s on the question of addressing police accountability, one of the central questions that they put forward was the question of how the community can exercise control over law enforcement. And what became clear to many of us as trying to get more community control, it became clear that the LEOBR was a major obstacle to this kind of community oversight. In fact, in 1998, 1999, there were efforts of folks in Baltimore City to try to get a civilian review board. So that's why we have the civilian review board in Baltimore City as a result of activists in the community, Councilman Kwabi Amiomi, and many others who were trying to get civilian oversight. Unfortunately, as many of you know, the Civilian Review Board in Baltimore City does not have the powers that the community would want it to have in terms of adjudicating and imposing discipline. So again, this is why the LEOBR for us has been central, because it's been a block to community control, community oversight. Senate Bill 627, as introduced, was based on the idea of what mechanisms legislatively can provide the community, should it be sufficiently well organized, the most tools available to be able to have control over its police department and have the ability to engage in community oversight. And so we were clear that some folks that perceived 627 as introduced as merely just shifting power into the hands of chiefs. We've been very clear that both the FOP and police chiefs have a role as to how we got to where we are, and that they both share responsibility as to why policing is in the state that it's in. And so that's why the community oversight provision, as Ms. Emanuel mentioned in her testimony, was so fundamental, and we saw as supplemental to the work of 627 as introduced. And this is also why, as we discussed earlier, the Maryland Public Information Act, we saw as a supplement to what was introduced in 627 to provide the public the information that it would need to be able to effectively hold police chiefs accountable with the information that the public does not traditionally have. Unfortunately, as 627 left the Senate, civilian oversight was gutted. Having civilians on a trial board does not constitute community oversight. As was already mentioned, there's no process outlined as to how those civilians are selected. And so it's for these reasons that Senate Bill 627, as it has been amended and as it has left the Senate, we urge an unfavorable report.
Thank you. I don't see any questions. As such, that concludes the testimony on Senate Bill 627. Moving on to Senate Bill 71. And I believe Senator Sidnor is entering the room. And there were some other folks signed up, Carrie Hansel, Lawrence Greenberg, and then 2 favorable with amendment, Joseph Riley and Stephen Kroll. So we'll let them come in. Apparently Senator Sidnor has been connecting for a while, so there may be a problem. If he comes in, we will let him testify. But I think it's safe to say he supports his bill.
Close that door, please.
Okay, we will start with Mr. Hansel for 3 minutes, please, on Senate Bill 71. You're on mute.
My apologies, Madam Vice Chair. Thank you very much. With respect to Senate Bill 71, on behalf of the group of trial lawyers who are also civil rights lawyers that I chair, we're very much in support of the bill. This bill does a lot of the same things that appear in the great work that has been done in this body in House Bill 670, which we also very much support. It adds one interesting wrinkle that I would like to discuss with this group, and that is the preclusion of testimony of police officers in criminal cases in which there is a finding that the body camera was inappropriately turned off. In other words, if a prosecution is being brought against an individual, the judge finds that the body camera should have been on and was not malfunctioning and those types of things. This bill adds the requirement that the officer not be able to be competent to testify. We very much support that small difference between this and 670, and further would support an extension of that preclusion of the officer's ability to testify with missing body camera footage to civil cases involving civil rights violations as well. For the same reasons that an officer ought not be able to reinvent what happened in the situation where a body camera is not turned on when it should have been and is functioning in a criminal case, that should also happen, we believe, in a civil case. So for that reason, we support this critical difference and support the bill while also very much supporting 670 out of this body, House Bill 670. Thank you very much.
Thank you. And I see that our good friend, Senator Sidnor, is here. Always good to see you. We miss you over here.
Always good to come back to my committee. Miss all you all. I mean, well, there's a number of new members I never had an opportunity to work with. So hello to all of you. And I can go ahead and start?
Yep, go ahead.
Thank you. So Senate Bill 71 is a bill that does three things. One, it mandates body cameras, which I believe you all had legislation that kind of speaks to that as well, by July 1st, 2025. However, prior to that, July of 2023, there will be at least 4 police departments that will be mandated to have the cameras. That's the State Department or the Department of State Police, Anne Arundel County, Howard County, and Hartford County. It also creates a rebuttable presumption for those officers that intentionally failed to put on their body cameras, which I believe I may have heard Mr. Hansel just speak with. And it establishes a task force on statewide body camera implementation that will continue looking into some of these issues as we try to iron out and make certain that all of our law enforcement have body cameras by 2025. That is the overview of the bill, and I would hope that you all will be able to report it out favorably. Thank you.
Thank you, Senator. Next, Mr. Lawrence Greenberg.
Thank you, Madam Vice Chair. Following Mr. Hansel and then Senator Sidnor makes it quite difficult, so I will not repeat. What I can tell you is, in addition to the civil work I do, I also do criminal work. And this committee has heard multiple of my clients who have come forward and explained instances where police officers turned off the video or intentionally didn't turn on the video, but it was caught from another officer's standpoint and their body cam. And this is a common sense bill. Mr. Hansel and Senator Sidnor addressed the built-in safety features with the presumption. I know the opponents are strongly against certain of these, even with the presumptions. But I can tell you, I have seen firsthand the realities of what happens when bad things go on with body cameras. Scott Schellenberger, I've listened to him testify. I know he's an opponent of this bill for reasons, but he is strongly in favor of body cams. And, you know, it's important that this bill should be favorably reported on. Thank you.
Thank you. I see Delegate Conway has a question.
Thank you, Madam Vice Chair. I have a question for the maker of the bill, Senator Sidnor. Hello, Senator. How you doing?
How you doing, brother? Delegate.
Oh, okay. How did you come up with this wonderful idea about these body cameras?
You know, I'll be honest. It comes from the committee. I had put in the rebuttable presumption, and in the committee they took it and added a number of these other features. So I was not the originator of these ideas.
All right. Well, that's wonderful. Keep up the good work.
Appreciate it.
Oh, Senator, don't you miss us?
I certainly do, and it's always a pleasure to come back and see you all and look at the good work that you all are doing.
Good to see you. Thank you.
Have a
Thank
blessed
you,
one.
panel.
Thank you all.
Next, we have two favorable with amendment, Joseph Riley and Stephen Kroll. I see Mr. Riley. Would you like to go ahead?
Thank you, Madam Vice Chair. Distinguished members of the committee, my name is Joe Riley. I'm the United States Attorney for Caroline County and the Legislative Chair for the Maryland States Attorneys Association. Senate Bill 71 talks about an important tool being used throughout the country today, and that's body-worn cameras. However, this tool cannot be fully utilized unless states' attorneys' offices throughout this state have funding to review these important pieces of evidence that have to be turned over. We have to view them first. We need eyes on these videos. We can't just hand these videos over to the defense on a particular case and say, here you go. Why? Because there are very important things that are put on prosecutors, very important ethical obligations that we have according to Maryland v. Brady. We have to notify the defense of a potential Brady problem. Something in this video does not match the report, for example. And it is a burden that is placed on us. So we can't just rely on the report and hand over a video and give it. We have to view the video first, see if there's any Brady type material, and then hand it over. If we're going to continue to increase the number of people that have body-worn cameras, and we hope you do, we need to have funding for individuals to put eyes on these videos. And we don't think that that is a too terrible of a request to make. So we thank you. Look forward to answering any questions that you have on this bill.
Thank you. Steve Kroll.
Good afternoon, members of the committee. I'm Stephen Kroll, the State's Attorney Coordinator, Maryland Executive Director of the Maryland States Attorneys Association. And we are 101% in favor of body-worn cameras. They are effective means for all parties, the public and law enforcement. I agree with Mr. Riley. Our concern is fiscal. Please make sure when you pass any body-worn camera bill that the fiscal is acknowledged and recognized and looked at. You know, I looked at the fiscal end from budget. I don't understand much budget. I tried to understand it, but I can tell you that anything when it comes to body-worn cameras has to be associated with budget. It's important this not be an unfunded mandate. It needs to be funded. We are 101% in favor of it. We want to see it succeed. So please fund it properly. Thank you very much. I'm happy to answer any questions.
Thank you. And seeing no questions, that concludes the testimony for Senate Bill 71. Moving on to Senate Bill 74. We just have Senator Washington here. And good afternoon, Senator Washington.
Good afternoon, Vice Chair. How are you doing?
Good. How are you?
Good. It's good to see everybody. And just like while I didn't serve on your committee, I do miss seeing all of you. It's good to see you. For the record, Senator Mary Washington for Senate Bill 74, and I'm going to ask the committee for your favorable report. You heard this bill last year as well, and you've heard the bill that the cross-file is Senator Delegate Brooks. We both cared very much about this issue. It came forward from constituents. As a matter of fact, I come to this bill. My brother is a police officer in Philadelphia. I have constituents who have family members that are police officers, and specifically, I was approached by a woman who is the wife of a police officer and was really expressing to me, asking for help to get support for their family members that are on the force, and looking at the issue of, what does it take to have constitutional policing? What does it take to have a good workforce? And she really asked us to make sure that we address the challenges that officers have in protecting our society. So while this is, and I'm honored and I'm glad it's part of the package, it's also something that this body has expressed an interest in, and that members of your committee has expressed support of. This bill does not require law enforcement agencies that already have a county employee assistance plan to develop and implement a plan, but it does require law enforcement agencies to prioritize members' needs as it pertains to their mental health and their physical health. And these are studies that have shown that directly correlates to performance, and also it directly correlates to reducing suicides, domestic violence, and excessive use of force. You already heard this testimony. You know that 1 in 4 police officers have had thoughts of suicide, that they're 1.5 more times more likely than the general public. There's higher rates of depression. And that while there are some good programs in other jurisdictions, we believe that this should be statewide policy. And then finally, I believe with the amendments that I want to draw your attention to, I believe that we've addressed some of the issues. In contrast to last year's bill, all of the stakeholders were a part of suggesting amendments, and additionally in terms of using language, one of the amendments changes the language from mental health evaluations to resiliency sessions, with the idea that we're talking about building the strength and the capacity of our workers and of our police officers, and not stigmatizing them. And I believe, again, I think we've come up with a piece of legislation that is complementary to and really vital to ensuring, again, our police officers, not only as public servants, but also as workers in the state of Maryland. So I ask for your favorable report of SB 74, and I'm here and happy to answer any questions you might have.
Thank you. I see one question from Delegate McComas. Delegate McComas.
Hello, Delegate.
Good afternoon, Senator. Glad to see you. I have one question. Could you kind of explain the concept of resiliency instead of, I guess, a mental health go back to work procedure?
Yeah. So I think I tried now, I went over it quickly. The connotation of the word, I guess, mental health, as you all know, behavioral health has some stigma attached to it, and it's just about sort of diagnosing. Right. Whereas resiliency, we're building resiliency programs that not only are we diagnosing, but we're going to provide the tools and the supports that police officers and law enforcement officers need to bounce back. So we're seeing that it's this give and take, that we're going to build on the strengths and not simply tear down. And that was important language, that some law enforcement officers and people who do this work said that they felt it was really important that our law reflect that language.
So is this a fairly new field as far as, or has it been around for a while?
No, we've been doing it for a while. It's just in every field, there's just different language and that they think better reflects what they're trying to do. So using that term of resiliency, like you over the years, in terms of domestic abuse, we often would talk about people who are the victims of assault, and you've seen the language talk about individuals as survivors. That does a different conceptual turn, and that's what we're trying to reflect in this legislation. That it's not about stigmatizing, but it's about diagnosing and then giving the tools back to get back to work. Also, another important component is that this work can be done confidentially, so that someone can seek help without feeling that it automatically will make them ineligible to be a law enforcement officer, and that they can get that support.
Okay. Thank you, Senator.
Thank you.
Seeing no more questions, that concludes the testimony for Senate Bill 74. Thank you, Senator Washington.
Oh, I wish I could stay longer, but it's good to see you all.
Committee, I am going to circle back to Senate Bill 71. I was so excited to see our former colleague, Senator Sidnor, that I forgot to let two folks testify unfavorably. So I will call Michael Davey and Mr. Boatwright.
Thank you, Madam Chair, Madam Vice Chair.
Sorry about that. I apologize.
No, it's no worries. We're fine. So in reference to Senate Bill 71, we will urge a unfavorable report. I think we come from a standpoint, we don't want to be in a position where we're now saying that our police officers' testimony should not be captured or admitted into a courtroom because the body camera was not running. I think that our police officers go out to every day to serve the public, and to have a presumption that they're lying because it's not captured on a body-worn camera just doesn't send the right message to our men and women in uniform. So, I'm not going to belabor the point, but just to say that we will urge an unfavorable report, and our officers should be given the opportunity to present expert testimony, because that's the way our system is set up. So I thank you for the opportunity to speak, but we urge an unfavorable report.
Thank you. Mike Davey.
Thank you, Madam Chairperson. Obviously, myself, Mr. Hansel, and Mr. Greenberg very rarely agree on a lot of things when it comes to the law enforcement and testimony and things of that nature. The FOP is clearly in favor of body-worn cameras. That have been. That's not even an issue. Our only concern about this bill and why we're opposed is the section regarding the rebuttable presumption. If you look further in that bill, it says that the presumption can only be rebutted by a malfunctioning camera, or if it was unsafe, impractical, or impossible. Well, that doesn't go far enough. You have other issues. What if you're one of your witnesses, you deactivate your camera because the witness is a juvenile, or an unwilling witness who doesn't want to be on camera, or it's an informant, or you're in a hospital situation where there's people walking around and there's HIPAA law violations, things of that nature. By limiting the presumption or the ability to rebut it based on simply a malfunction just doesn't go far enough. I know Mr. Hansel and I know Mr. Greenberg very well. They are very competent attorneys. If one of their clients is in a criminal case and that officer deactivates their camera, trust me, they will be all over it and judging and questioning the credibility of that officer and why he shut it off. And then it will be up to a judge or a jury to determine whether the officer is credible or not based on that rationale. And it should be left up to the jury or the judge to make that decision. It shouldn't be left up to the fact that you just can't testify unless there was a malfunction or it was impossible. Situations happen. It's unfortunate. Police work is very difficult. It's fast moving, and it has a lot of layers of investigation. And when we start dealing with juveniles as witnesses, informants, Baltimore City has a major problem with people not wanting to come forward. Trust me, if they don't want to come forward, they're certainly not going to want to be saying who shot so-and-so on a body-worn camera. And if an officer shuts that off, he shouldn't be prevented from testifying at that point to what happened during the course of that investigation. So we believe the section related to the rebuttable presumption simply goes too far and should be amended out of this bill. Thank you.
Thank you. I see Delegate Conaway has a question.
Thank you, Madam Vice Chair, and thank the panel for coming in to testify. So Mr. Davey, can you speak to what the body-worn camera has to do with the consent decree in Baltimore City?
The consent decree requires the body-worn cameras be in place, and who is going to wear them and how they're going to be worn and when they're going to be used. But what the body worn, and Baltimore City has a I think it's a 16 or 7-page policy on how it's going to be used. And it lays it all out. There's nothing in there. And of course, if there's a malfunction, you have to report it. You have to write a report prior to your shift or during your shift, or notify a supervisor over the air. But there does come times beyond a malfunction that you are permitted to shut it off, or what they call deactivate it. You never shut the power off completely, but you just push the button and deactivate the recording during the course of an interview of an informant, or discussing with a supervisor an investigative technique, or a juvenile, or someone who simply doesn't want to be on body-worn camera. So the consent decree requires the body-worn cameras, but it's the policy that drives how it's used.
What about when you enter a house in a domestic event and it might be nudity or something like that?
Sure, then you would want to shut it off. It really depends on every department's individual policy. And because every department has a different policy, you'd have to look at each individual agency.
So there's not a single policy across Baltimore City with the consent decree?
In Baltimore City there is, but this policy in Hartford County for their body-worn cameras, or Prince George's cameras, our policy can be different, have different aspects and speak on different things.
So would you say that it could be said that Baltimore City's policy on these body-worn cameras are a little more stricter than other jurisdictions?
I'm familiar with Baltimore City's, and I can tell you it's very thorough.
All righty.
It's very thorough. And they even do audits after the fact.
Thank you very much.
You're welcome, sir.
Delegate McComas?
Just briefly, this is for Mr. Davies or Mr. Boatwright. Baltimore City has a reputation of no snitching, and it's kind of a cultural thing. And so I know the Dawson family, because they had problems, the whole family was wiped out through a firebomb. And this was years ago, but I think that there's still this kind of culture that if you talk to the police or you're seen to talk to the police, it's a problem. So because of the gun trace task force and just because of consent decrees and just, a lot of problems as far as just, I guess, their PR, Baltimore City Police Department doesn't have a great reputation. So I guess my concern is use, this limited use of the body cameras. I would think just this cultural problem with stop snitching, don't snitch, that a lot of the people would be fearful to talk on film to any police officer. And I was wondering, is that a correct assumption on my part, or so that in other words, this rebuttal, this very strict rebuttal, is going to make it harder for prosecution of crimes, because a lot of people aren't going to want to talk to you. So would you kind of comment to that?
You are 100% right, Delegate McComas. Baltimore has a big problem with the public not trusting the police, and that's why we're here for police reform. But now when you're required to wear your body-worn camera, citizens don't want to be on camera saying who committed what crime because they're afraid of retaliation. And if we can't deactivate the camera for people who are afraid of that reason, knowing that if you deactivate it, you can't testify as the police officer in that case, it's going to cause a major problem in the ability to convict certain criminals and the willingness of citizens to come forward and speak to the police and provide information.
Because isn't it just hard now to get people to come forward? I mean, the little girl that was killed, I guess it was a number of years ago, on her porch. I mean, it took years before somebody came, that they found out who did it.
That would be the Mackenzie Elliott case.
Yes,
I'm familiar with that case. And you're right. She was shot sitting on her porch in broad daylight, and none of the neighbors would come forward in fear of retaliation. And clearly they're not going to walk up, in my opinion, they're not going to approach a police officer knowing they can't shut off or deactivate their body-worn camera and provide information knowing it might get back to the actual shooter.
Okay. Thank you, sir. Mr. Bodwright, do you want to comment, or?
No, I was just going to say, as a man that wears a uniform, I'm pretty familiar with the stop snitching culture that started from the Poplar Grove community, which I patrolled. And so that stop snitching culture, where people would not communicate with the police. I can tell you now, if we had to have a body-worn camera on just to interview a regular citizen, Miss Jones, who's sitting on her porch, and if Miss Jones tells me someone was the suspect of something, and I use that in an investigation, and it comes back that I didn't have my body worn camera and we did get the correct suspect, now we've deprived the victim of justice. So we don't want just the fact that a police officer did not have the body worn camera activated to be a reason for a suspect of a crime to go free. So that could be the most important information that a police officer gets. And it could be with, like Mike Davies says, with the deactivation of a camera, just to get that information from a citizen who wants to help out and rid their communities of people that are causing harm.
Thanks, sir.
Thank you.
Thank you, Madam Chair.
Delegate Conway.
Thank you, Madam Vice Chair. I know you're going to get me the second bite. Mr. Boatwright, you also are aware that sometimes a situation could happen where a person could appear to be interviewed and not really be interviewed about the situation, but then be accused of snitching and therefore be under the pressure to tell everything that they know and try to get police protection, right?
Yes, that interviewing someone in the public eye, and that could cause some safety concerns. I agree with that.
Yeah, what I'm saying is the reverse, where officer interviews you and knows that everyone's seeing you being interviewed. So now, even if you don't tell anything, the presumption is going to be that you told everything. So you might as well tell everything you know to try to get police protection, right?
Oh, that's absolutely correct. But there's a way to do that. If you're a police officer and you have a relationship with your community and the person wants to talk, there are other ways that you can get that information from the citizen that don't involve you doing it in front of everyone out on the crime scene.
Right, but by the same token, you can interview somebody who does not want to cooperate and force them or compel them to cooperate based on what the perception of the community will be.
Well, I think as a matter of safety, you don't want to compel someone who is unrelenting on a crime scene, because you don't want to give someone a black eye in the community as though they are communicating with the police and they're not. So you don't.
Okay, I'm not going to say something smart like when did that start, but anyway, thank you.
Thank you, Delegate.
Thank you. And now that concludes the testimony for Senate Bill 71. And for our last bill, Senate Bill 786, Senator McCray was waiting since we began at 1:30. Kaylin Young and Natasha Mayhew. And Senator McCray, are you with us? Okay, he might not be with us. Okay, so we will, if he hops on, we will give him the mic, but we'll start with Natasha Mayhew.
Thank you. Good afternoon, Madam Vice Chair, members of the committee. Natasha Mayhew here on behalf of the Mayor of Baltimore City in support of Senate Bill 786. Local control of the Baltimore City Police Department is the top priority of Mayor Scott's administration. And since this committee has already heard the House version of this bill, since then we have heard from a wide range of stakeholders and have worked to address any additional concerns that were raised. So the Senate bill before you incorporates additional amendments intended to strengthen the bill and to generate consensus on a path forward for local control of the Baltimore City Police Department. The bill establishes an advisory council of key stakeholders to guide and oversee the transition. So additional representation on this advisory council includes the city solicitor, a representative from the Civilian Review Board, 3 members of the community, 1 representative from the FOP, 1 representative from the Vanguard Society. And to ensure that residents have a voice in the matter, the bill, the transfer of control is contingent on the passage of an amendment to the Charter of Baltimore City and its ratification by the voters. So the Senate bill, we added an additional amendment to ensure that happens sooner than as initially drafted in the bill. So if an amendment to the Charter of Baltimore City is ratified at the 2022 general election, the transfer will take effect January 1st, 2023. If the amendment to the Charter providing control is ratified at the 2024 general election, then the transfer will take effect January 1st, 2025. I do want to note 2 additional amendments we are offering in response to concerns we've heard, and that would 1, clarify that the bill does not strip police of their collective bargaining rights, and 2, clarify that members of the advisory board appointed by the mayor are subject to confirmation from the city council. So these amendments afford the city government, city council, city delegation members, police officers, advocates, and importantly, community members, really all the necessary stakeholders, the time, the process for guaranteeing the transfer occurs with foresight and precision. And so I just want to stress that this is truly a process that considers the people and the specifics of what local control will entail, and thoughtfully considers additional concerns that have been raised these past few weeks. And so with that, I urge a favorable report on Senate Bill 786 and urge the committee to conform the House cross-file accordingly. Thank you.
Thank you. And now we have Senator McCray. It's great to see you. Thank you for being so patient. I know you've been holding on since 1:30, but you know how we do.
Yep, for the record, Corey McCray, 45th Legislative District. Just wanted to say I'm here in full support of what Director Meehue stated in reference to our Baltimore City Administration Bill. Believe that it's been worked out with all parties, Madam Vice Chair, and I just thank you for Judiciary giving me this opportunity. I do know how y'all do, so that's why I had to put in here and say hello to my friends. So thank you.
Thank you. And last we have Kaylin Young.
Thank you, Madam.
Go ahead.
Thank you, Madam Vice Chair, members of the committee. Kaylin Young, Director of Public Policy at the ACLU of Maryland. Happy Maryland Day. I have my little tie going on today. We are standing here in support of this bill, echoing Senator McCray and Natasha that we have been part of those conversations about those additional concerns, and we are in support of the new amendments as well as the ones that the Senate put in place as well. We urge a favorable report as a result. And I'm speaking on behalf of not just the ACLU, but the Maryland Coalition for Justice and Police Accountability, as well as the Campaign for Justice, Safety, and Jobs. Thank you so much.
Thank you. Are there any questions? Seeing none, thank you all so much for being here today. And that concludes the testimony for Senate Bill 786. Committee members, the subcommittee chairs and backroom folks will be meeting at 4:45. So that concludes the hearings for today. Also, we will be voting tomorrow afternoon. All right, that concludes the hearings.